Good afternoon, good afternoon. How do? Alright. Today we're going to talk about, it basically falls under an instrument offered in fraud. So what we're going to talk about is that waiver that the Labor Relations Department basically force an individual to sign under intimidation. How it goes into that is where they say if you don't sign it, we're going to go to 40 rector, and we're going, instead of going for 30 days, we're going to go for 60 days or termination. The key factor in even saying that would constitute intimidation, which is in violation of the employer's corporate compliance policy. It's also in violation of New York State penal law. Yes. That would be subsection 13560 under threat and coercion. See, because the key act is you using coercion. I'm going to coerce you into doing what I want you to do and what's against your rights as an employee. Okay? So, the mere fact that they gave you the instrument and forced you to sign the instrument, you could put it under duress, but you signed the instrument, make a documentation. They forced me to sign this instrument. You know, I really didn't know what I was doing. I wasn't really informed, because when the union business agent is supposed to tell you before the action takes place. If they don't tell you, who are they working for, really? So, let's move forward. How do it become fraud? Let's just say this. Once the labor relations specialist says that you have to sign it, and you're forced to sign it, and then the labor relations director moves forward, knowing that there's a EEO issue, there's a whistleblower in place, because you told the labor relations specialist at the meeting, at the beginning of the meeting. But she still says, nah, you're going to sign this. You're not even paying attention to that. Not a problem. You've been informed. Now, so they move forward. They take that document, use it as an accusable instrument, as evidence. Just fraudulent document. You got to remember, because it was entered in void, which makes it fraud. So now you go to 40 rector. We got this, and that. Did you ever address the whistleblower? No. You do know once it was the fact of a whistleblower, Civil Service Law Section 75B kicks in. Not only that, New York State Labor Law subsection 740 kicks in. You are in New York City, right? New York City Local Law number 33 under whistleblowers kicks in. The mere fact that you did not exercise the employee's right with these three laws kicks in a constitutional law. Yeah, that would be that U.S. Constitution, that U.S. 42. Deprivation of a right. That's that Jackie Robinson. I like calling it Jackie Robinson because the number 42. So, deprivation of a right. You deprive them of a right under Civil Service Law Section 75B, under New York Labor Law subsection 740, under New York City Whistleblowers Law local number 33. It's depriving. So let's move forward. You then took this instrument and you entered into arbitration court. Yeah. So you entered with dirty hands. Entering with dirty hands, entering in equity with dirty hands. The court operates out of equity. With dirty hands, mean you're entering with fraud. Once again, the ship cannot sail. You already torpedoed the ship. If technically they wasn't even supposed to let you on the ship. So once you came into court with that information, the judge is supposed to say, it's a no-fly zone. You're out of here. The case dismissed. But you got the officers of the court to work with you. That would be under administrative law judge. Under what is that? That would be that it's under the administrative law judge, and is falling under arbitration. Where arbitration, the arbitrator usually goes with the larger company, who's employed by the company. So the key fact for the individual to do is show how those officers of the court violated their canons, such as the judge canons 2, mere appearance of an impropriety, and lawyers canons 9, mere appearance of impropriety, which kicks in New York State's judicial code of conduct. We're just gonna go to, we could go to 3.3, which is conduct within a tribunal. You don't want to mess with that. Then we're gonna go to 4.1, your truthfulness. We're gonna go to 8.3 because the clients representing or the officers representing the attorney was supposed to point out the fact that what they was using. You didn't want to do it. You was embezzling. So we're going to go to 8.4, which is just misconduct. Misconduct by an attorney. Which goes down to your truthfulness, your honesty, your integrity, all of that. Shows how you get stripped. And then from 8.4, you go to 8.5, what you file with the judicial committee. And you know how they work it. You know how they work it. It's one of our friends. Well, let's expose your friends on this level. You can't work it no more. It's all exposed. So let's move forward again. The key factor they do this brings about fraud upon the court. Under fraud upon the court, you can use ultravirus. Ultravirus is basically saying how they went beyond their powers of the corporation. You do know you register with the corporation when you take that oath. And under that, your powers is basically lined out under your canons. So when you violate your canons, you violate your jurisdiction. Basically lose immunity. Fall under, what's that? Judicial Code of Conduct, which would bring about subsection 487. Misconduct by an attorney or counsel. Class A misdemeanor. That's just done, but let's go back to the Labor Relations Department. Said actions to violate their corporate compliance policy brings about 19500 misconduct, official misconduct because they are public servants. It also brings it to basically 2020 criminal liability of subsection 2020 of a corporation, and criminal liability 2025 subsection 2025 of criminal liability of a corporation because they are an employee. Based on the fact they're all working together, subsection 105.000 conspiracy. You got all these fraudulent instruments and they punishable instruments. Under the punishable instrument is 21045, right? Class A misdemeanor. Then we're going to throw in 19500. No, 195.05, which would bring about obstruction of governmental administration because you didn't follow your due process. We're going to bring in that you filed it on the record with all of these documents. So we're going to go to subsection 175.35, which is Class E felonies. You filed this and it went to other entities. Subsection 496.02, defrauding the government. Yeah. So, no. I don't know what to tell you. You just violate your corporate compliance policy. So, putting the person through all of this brings about what? That remedy. You do know that based on the fact that you violated the whistleblowers, that kicks in punitive damages. Because the whistleblower is there and it falls under your 5th and your 14th Amendment under due process, under fundamental rights, which brings about due process. And then the minimum amount of due process that you violate kicks in your substantive and substantial right, which vetoes your decision. Or vetoes their decision. It's not hard to figure out. Just a little more reading. So, I guess that's why they terminated a number of them to bring about the deniability. But too late. Too late. Oh, it's the statute of limitations. Sorry. All we got to find out is that you did it and you got it on the record. So on that note, we're gonna follow the real deal based on the facts. The facts cannot be altered nor denied. And in closing, have a wonderful day. Later.